We are live. Today is April 14th, 2020. Got my good friend, Mackenzie Simmons, Marketing Director here at the Hacking Law Practice. Mackenzie, how are you doing?
I'm good. How are you?
Oh, I'm pumped up. I've spent the last 2 days thinking about marketing and the Hacking Law Practice and all the things that we talk about. I was working with my mentor, Mr. Dean Jackson. By the way, I'm filming in conference room A, and I think the sunlight is about the best light that we've had so far. So I'll probably do these from in here from now on.
All right.
All right, you said we got a lot of people signed up. Looks like 55 people in the room. If everybody, give us a message in the chat. Tell us where you're from. Introduce yourselves. Mackenzie's going to feed me the questions here. We're going to give people another minute or two to get in, but we'd love to hear from everybody. Let us know where you're from, and just say hello. Cesar likes our YouTube videos. That's great. Panama, New York City. Nice. Now, listen, before we get started, let me just mention that last time somebody sort of sent us some mean emails saying that we didn't get to their question, like we were purposely avoiding them. Mackenzie goes through the questions and tries to think up or to hit on topics that have sort of universal appeal. We don't really have the chance to give big, long, detailed analysis of people's cases. That's sort of what the purpose of a consult is for. We want to help as many people as we can, and we want to hit as many topics as we can. So if we don't get to your topic, we are sorry, and we will try to make it up to you next time. This is a free service that we offer as a service to the community, and we're happy to do it. We also come up with some good YouTube videos. So if you don't get your question asked and you do still have a question that you think has general appeal to people, that would be helpful. And that would be the kind, and you can feel free to email us at info@hackinglawpractice.com, or I guess now we have contact@hackinglawpractice.com. Is that right, Mackenzie? All right. So we got that'll work. And then of course you can always shoot us a message just in the YouTube or in Facebook. So we get a lot of people reaching out to us on Facebook. So let's go ahead and get started.
All right. So Will said, if my visa package is front-loaded and well-organized, does this make the interview at the embassy for my spouse a few minutes from approval, or does it make it easier?
Yeah, that's a great question. It was Will?
Yes.
All right. So definitely having a well-organized packet is a good idea. You know, when you do a spouse or fiance or any kind of family-based case and you're going through the embassy, there's sort of three stages. You have USCIS, you have the embassy, you have the National Visa Center, and then you have the embassy. So usually by the time the case gets from the National Visa Center to the embassy, for the most part and under normal circumstances, they have pretty much everything they need to issue the visa unless they want to cause mischief or trouble. So yes, having a well-organized packet that isn't missing anything, I think is your best bet. When I was in law school, they taught us this concept called arbitrary and capricious. And what the concept of arbitrary and capricious means is that the law is supposed to be applied uniformly, the same way to everybody. And you're not supposed to have your case turn on which immigration officer you get at the embassy. But the fact is that individual officers are individuals and they have their own things that are important to them. I remember we used to have an officer here in St. Louis who would get all bent out of shape if somebody didn't have their driver's license updated. So you never know exactly, and you can't control things, but you have the right mindset. The right mindset is, how do I take away reasons for them to say no? How do I eliminate all of the potentials for error or for delay? And so yes, having a well-organized application will increase your chances of having a fast interview at the embassy. It depends on lots of different variables. It depends on the embassy. It depends on the embassy setup. It depends on the rules within that embassy. It depends on what your race is. It depends on whether you've tried to come to the United States before. It depends on lots of different variables. But undeniably, getting the most organized packet out to them is the way to go. And for the person going to the interview, the most important thing is that they can easily access whatever is asked for. So you don't have everything bound up. You want to have it all easily accessible, organized, and that the person going to the interview should know where everything is so that they can access it quickly.
Okay. This one's private, so I'm not going to say the name, and it also is kind of long. So I'm just going to kind of sum it up for you. So this person filed an I-485 for a primary with a derivative. Yeah. The primary applicant got the green card, but the derivative is still left pending for, it looks like, a couple of years now. What are his options?
That's interesting. That should not have happened. I wonder why that happened. If it's been a couple of years, then most likely something went off the rails, and I suspect that it might be related to age. They might have thought that the young person, the derivative, aged out. But you're going to need to file a lawsuit most likely to get a final decision on the derivatives case. We never find out why it's delayed, but the fact that it's been delayed for a couple of years or several years, that's a sign that nothing's going to happen unless and until a lawsuit is filed.
Okay. We got a question from Ahmed, but the topic seems to be pretty popular. So he is a visa holder, but his visa ended in March. He applied for the extension, but he couldn't leave because of coronavirus. And so his extension is still pending. What should he do if they reject the extension? And then also, I guess,
does filing the extension itself protect him in any way?
Right.
Yeah. Okay. So in the good old days, even before President Trump, in the good old days, getting an extension was relatively easy. So to get an extension, you would file a form called an I-539, and you could hang out for as long as it took to decide. Now, back then, those cases took about 4 months to decide. So one sort of easy way to buy yourself some more time in the United States was to file for an extension. Now, we still would discourage people from doing it. And the reason that we would discourage people, even back in the good old days, from filing an extension of status was that at some point in the future, you're probably going to renew your visa. So for those of you who don't know, on a non-immigrant visa, most non-immigrant visas are multiple entry visas, but some non-immigrant visas are sort of good for 1 year only. So in that situation, you're going to have to go and apply for another visa all over again. And if you've overstayed your 6 months, even with an extension being filed and or granted, the embassy is not going to like the fact that you did not come back on time, that you did not come back when you said you would, and that you asked for this extension. And that was true in the old days, and it's certainly true now. But life has changed for people looking for an extension. Most extensions these days are denied, and you are looked upon very harshly for filing an extension. So obviously these are very strange times right now with the coronavirus, but absent the coronavirus, we have been telling everyone not to file for extensions, and we have filed very few extensions. Now, we do have a client right now who we helped a U.S. citizen who's actually a military contractor, and he brought his wife over, and we got her a green card, and then her mom came to visit. And sadly, it turns out that her mother has pretty much terminal cancer. She's going to pass away here sometime. And so we filed an extension for her on that visit, and it was granted. And now we have filed a second extension, and in today's mail, we received what I would call an impossible request for evidence. We received a request for evidence for all the medical records, for an updated letter from the doctor saying that she needs to be here. We made it very clear that she's dying of cancer, but they don't care. So if this woman can't get an extension, most people are not going to get an extension. But turning our attention to people who had every intention of leaving and are just stuck here because of the coronavirus, what I would do is I would file for the extension, and I would keep my receipt once I filed my extension, and I would leave as soon as I can. I wouldn't know. As soon as flights reopen, as soon as I have the ability to leave the United States, I would leave it with that application pending. Then at the very least, if you ever have to renew your visa or enter again on the visa that you had before, you can show them, look, I left as soon as I could, and I filed the extension. I did everything possible to stay within the law, and I'm not God. I can't control everything, so I did everything I could. So that's the best it's going to be. It's not going to be any declaration that, oh, you did everything you were supposed to do. It's just trying to make the best of a bad situation, and later on giving yourselves some things to argue about whether or not you follow the law.
Okay. So I had one, but it seems that we're getting so many comments, they're starting to delete themselves.
Oh,
So,
really?
yeah, so if you already asked your question, don't put it again, just keep it there and I'll get to it.
Oh, like you only have a certain amount of feed and then it pushes
Yeah,
them
apparently
out?
I was pretty close to the bottom and they just started disappearing.
Oh,
And
wow.
my guess is because people are keep commenting at
All
the
right, well,
top.
I'll try to talk a little faster.
Okay. Okay, so Zaid asks, is it a problem if I have unpaid taxes upon applying for citizenship? And if it would affect the case if he gets a divorce, although he has had his green card for more than 5 years?
Okay, so Zaid is thinking about applying for citizenship. He has two questions. One, if I get divorced from my U.S. citizen spouse, will that affect my ability to naturalize? And two, I have unpaid taxes, and will that affect my ability to naturalize? So, Zaid, as long as you apply on the 5-year rule, and as long as the original marriage was valid, you won't have to reprove that marriage. You shouldn't have to reprove that marriage, and that's one of the benefits of applying on the 5-year rule as opposed to the 3-year rule. So make sure to wait the full 5 years from the date the green card was granted, and then a couple more days just to be close, to not cut it too close. As for taxes, if you have unpaid taxes, the best answer is to wait to apply until all of your taxes are paid. Because again, we always want to take away reasons for them to say no. If you don't have that as an option, then you need to enter into an IRS payment plan. You need to get all the documentation of the payment plan. I would suggest making payments on the payment plan for at least 6 months before applying, and you're still going to have a hard time at the interview because they're going to be pissed, or angry, I should say, that you got behind on your taxes. So I would say best course of action, this would be a good video, Mackenzie. Best course of action is pay off your taxes. Second best option would be to be in a payment plan with many, many months of making the payment to show that you intend to pay it down. And the third best option would be to just get a plan and then maybe make the first payment and apply right away. I wouldn't vote for that. I would at least do the second one, if not the first.
Okay.
Even sorry, Mackenzie. And don't forget, you can probably negotiate with the IRS. So, like, if let's say you owe $15,000, you might say to them, "Hey, I owe you $15,000. I'll pay you 10 in 30 days if you'll write off the other 5." I bet you they'll do that. And more importantly, you might take out a loan to pay that off because there's no rule about naturalizing if you owe money to a bank, but obviously there is when it comes to owing money to the IRS.
Okay. Irina asks, how do you think that the pandemic will affect her IR1 delay lawsuit?
Yeah, so for us, what we're seeing, so we're still filing our lawsuits. So the courts are still open and the courts are still issuing summonses, and that's how you get a lawsuit underway. So put coronavirus to the side for a minute. When we file a lawsuit, about a week later, the court issues these things called summonses, and we mail those by certified mail to the U.S. attorney and to all the defendants. And once they get that, the clock starts ticking, and they get 60 days to answer. So we are telling people to still go ahead and file those lawsuits because it's important to get your place in line, right? So you want to get that clock ticking, that 60-day clock ticking. There's no reason to wait to file because you're going to be at the end of the line if you don't do it now. So why not use these 2 months, however long the courts are going to be slow or the offices, the embassies are going to be closed. I mean, the president has made it pretty clear that he wants to get things operational as soon as possible. And whether that applies to embassies or not, I'm not so sure. But the federal government is going to be pushing to reopen things soon, if nothing else, so that he can say politically that he's done that, right? So as far as lawsuits that are on file right now we're giving extensions. So if a U.S. attorney calls me up and says, Jim, the embassy in Islamabad or the embassy in Casablanca is closed, we need to roll this out 60 days, I say, yes, sir, or yes, ma'am. We're not giving them any trouble. We're not fighting at all on this. We're being very, very reasonable because we want them on our side, because we always need the U.S. attorney's help when we file these lawsuits. So, Irina, it's probably going to affect it's definitely going to slow down your cases like yours that are already on file. We're just telling them you get your 60 days. They're trying to get us to agree to open-ended deadlines, but we're not doing that. We're either doing 45 or 60 days. Again, just because we're going to be reasonable and we want to be sort of at the head of the line when things get back to normal. Now, I will say, in certain cases, things are still moving. We had one of our lawsuit clients got their visa today. We had another client on a naturalization case actually got sworn in today. So we're going to put that in tomorrow's newsletter. But we have a client who, believe it or not, had a private naturalization ceremony today at the immigration office in Pittsburgh, Pennsylvania. So, I mean, for me, that got me all excited and got me pumped up, and I was really happy for our client, Wen Lee. But we'll be writing out about that tomorrow. And, obviously there's no guarantee, but if you operate from the belief, like I do, that the delay applies to everybody and it's relative, then just eliminate that from the analysis and do what you would normally do anyway, right? So that's sort of the mindset I have, is like, when I file the lawsuit, I'd rather have the lawsuit be dated April 14th as opposed to June 14th, because then it's older. The judge is going to be less inclined to give the government more time. Obviously, we're being reasonable in dealing with the courts and dealing with the lawyers, but still you're at the front of the line instead of at the back of the line.
Okay. Alexi says that they received their parents were admitted to the U.S. as IR5. Do you know if green card productions and delivery was suspended, or will they still get their green card in the mail?
If they paid their LSD, they should still get their green card in the mail. We've had like 3 come in this week, so the production center in Kentucky is still issuing green cards.
Okay. Samihan asks, if somebody enters the U.S. on a K-1 visa, marries the petitioning U.S. citizen, do you think it's wise to delay filing the I-485 by 2 years to avoid getting the conditional 2-year green card?
No, I think that is not wise. Why would anybody ever want to do that? Getting the conditions removed on the green card are not nearly as important as getting that original green card on file. If you wait 2 years to file, you might get a 10-year green card, but you might also get put into deportation in the interim. So she's authorized, the fiance, the person who comes on the K-1, is authorized to stay in the United States, but if they don't get married and if they don't file, they're subject to deportation. So that's a bad idea.
Okay. Muhammad wants to know if our office can file a writ of mandamus for delayed non-immigrant cases, and is it reasonable to do it in this situation?
Yeah, that's a good question. So obviously, with lawsuits, first we started doing citizenship lawsuits, then we started doing green card lawsuits, then we started doing asylum lawsuits, then we started doing spouse and fiance visa lawsuits, and then just last year we started doing non-immigrant visas. I believe that filing a non-immigrant visa lawsuit at this time still makes sense for the reasons I just mentioned, that you're still going to get to the front of the line, you're still going to get the attention of the U.S. attorney, you're still going to have the U.S. attorney calling the embassy to get the case moving. The U.S. attorneys are all working, and they have their contacts at the State Department or at the embassies, and things are moving. Now, you will be on hold because of the coronavirus and the closing of the embassies, but you'll also be at the front of the line when they reopen. So, in fact, with non-immigrant visas, we haven't even been waiting a full year to file the lawsuit. So if you're if you've been told you're in administrative processing, and as long as you're a reasonable person and not going to be mad at me because of the virus and the closing of the embassies, and if you understand that filing the lawsuit puts you more at the front of the line, then I would say yes, you can still go ahead and file a lawsuit. But you have to be realistic and you have to be reasonable. Like, I have a couple clients who are mad at me because the embassies are closed, and even though we filed this lawsuit, their case isn't moving. That I don't find that to be very reasonable. So I would say that if you understand all those things and you're willing to do it, we're certainly here to help you, but you've got to be in the right kind of a mindset.
Okay. How long does it usually take to receive the green card after its approval?
That's a good question. We have seen situations in the past where we get an online notice that the green card has been approved on a Wednesday. We get a letter in the mail with the 485 approval notice on Thursday, and the green card comes on Friday. And I would say that green card comes anywhere from 1 day to 6 weeks between when it's approved and when the approval notice is issued and when the green card is received. One of the big things, of course, is if you move, that's got your green card case. That might mean your green card doesn't end up in the right place.
A private question. So a private person said, who should be responsible for writing the letters for a 601 waiver for medical, or do you just need your records?
So some people are inadmissible into the United States, and they can be inadmissible for lots of different reasons. Might be an overstay, might be an unlawful entry into the United States, might be a crime. And there are certain waivers that are available to the inadmissibility findings. So the question is, who should write the letter, or whose responsibility is to write the letter? I think the question is too small. And what do I mean by that? What I mean by that is that you need to be thinking a whole lot bigger than who's going to write a letter or just mailing in the records. Neither of those things are going to get the case approved. An I-601 waiver or an I-601A waiver are very, very, very fact intensive. You need a whole lot of evidence. You need to walk the officer through why the U.S. citizen sponsor is going to be subject to exceptional and unusual hardship if the foreign national isn't allowed back into the United States. So, like I said, the question is too small. What the question should be asking is, what are all of the things that we want to include in an I-601 waiver? What are the ways that I can file the strongest case ever? Just mailing in a letter from the aggrieved U.S. citizen and some medical records is not going to cut it in most situations. So that's true all the time, but it's especially true right now when we have the Orange Cheeto in the White House who has directed USCIS to deny as many cases as possible. So I don't mean to be overly harsh, but it's going to take a whole lot more than a letter and some records to get a waiver of inadmissibility granted.
Leo said that his father is 87 and his mother is 78, and they just passed their citizenship interviews and received the ceremony scheduled for April 3rd, but it was canceled.
Yeah.
Will they have to wait for a ceremony reschedule?
Yes, they will have to wait for a ceremony reschedule. So I would imagine, I don't know this for sure, but I would imagine that when things reopen because of the backlog, that USCIS, at least, so one interesting thing about immigration is that every USCIS office is different. And I believe that they all sort of take on the persona or the operating structure of the person who's running it. So for instance, the field office in Fairfax, Virginia is very organized, very precise. I had a case where we had to postpone the interview and we got the interview notice back in the mail before the originally scheduled date, which is almost unheard of. So I would imagine that the immigration offices that do a good job and that are going to try to clear their caseload will have some pretty large naturalization ceremonies. I remember one time my wife was the guest speaker at a naturalization ceremony for 1,500 people at the Chaffetz Arena at St. Louis University. So I would imagine if I'm them and I have this big backlog, I'm going to try to do them all at once. Now, there might still be some coronavirus effects that might make them not want to do that. And it'll be interesting to see how they handle this. You know, there are some jurisdictions where you have to be naturalized by a federal judge, like where we live here in St. Louis. But like my client today in Pittsburgh, and I know Atlanta and Minneapolis, they have administrative naturalization. So if you don't change your name, you can do it with an officer. So it'll be interesting to see. I actually haven't thought of this about what'll happen on the back end of it as far as doing these ceremonies. But yeah, the long and the short of it is, logistically, they're going to have to figure out how they want to do them, and then they'll schedule your parents for their new oath ceremony.
Okay. Atif says that the common timeline listed on USCIS for an EAD card is 4 to 6 months. Does that time frame start after fingerprinting or when it was filed?
That's a great question. That timeline starts after fingerprinting. So in the old days, it was 30 days. So they've really done a lot to slow that down. And so, yeah, it's 4 or 5 months from the date of fingerprinting. So don't put off your fingerprinting. And in fact, I'll tell you a little trick. Let's say that you get your fingerprint notice, and this is again under normal circumstances. Let's say you get a fingerprint notice and you get it today, which is April 14th. It says, Mackenzie, come in on May 10th and get your fingerprints done. If Mackenzie were my client, I would say, Mackenzie, take that letter and go tomorrow if you're in a hurry, and tell them, hey, look, I know that you guys told me to come in May, but I'm really busy in May. I'm going to be getting married and graduating and all this stuff. Can I go ahead and do my fingerprints now? And then usually, if they're not too busy, at least around here and in other field offices where I've seen this work, they'll schedule you then, and then you move up that 4-month, 5-month calendar earlier by having an earlier fingerprint date.
Okay. Caesar says that he applied to be naturalized. However, he has a concern because in 2015, he was out of the US for 7 months, and in 2016, he was out for more than 11 months. What are his chances?
Okay, so Cesar, I would not have filed that case. That's an easy one for them to deny. So whenever you apply for citizenship, there's a couple things you have to show. One is that you've been in the United States for half the time, and that you haven't had any trips of more than 6 months. If you have a trip of more than 6 months, then the burden is on you to show that you did not abandon your residency. So what that means is that you are presumed, they assume that you abandoned your residency by staying out for more than 6 months. Now, you did it twice. So I would probably recommend withdrawing that case and waiting. You can wait 4 years from the date you returned from the 11-month trip. 4 years and 1 day is when you should apply again. So that application is most likely not going to be approved unless you have a airtight case to document that you did not abandon your residency, which I think is going to be almost impossible. I've seen people stay out because their mother was dying or they broke their leg, and those things didn't work. So unless you have real proof that you maintained all your resident stuff, that you didn't work out of the country, all these things, I would probably withdraw that case.
Okay. Omer says that he could not apply for an OPT because his school's international office is closed. What should he do?
He should scream his head off until he can find someone from the office and get them to issue it. That's ridiculous. Whatever school that is, feel free to email me and I'll help you track them down. That's complete and utter BS. And I don't care if you have to find the president of the university, you're going to get that taken care of. That's completely unacceptable.
Yervon asks, he applied for asylum and is pending interview, but his dad had filed a petition previously, which is now current. Should he proceed with the F2B that his dad filed or stick with his asylum?
Now, this is an interesting question. Run that past me one more time. I think I got it, but I want to
Okay.
So our man applied for asylum, and that case is pending. He hasn't had his interview. At the same time, his dad has a pending application for him as the relative of a lawful permanent resident, and he wants to know what he can do. Okay, so a couple things. Number one, you need to talk to a lawyer, so you should probably call our office. But over and above that, generally, what you need to know is, and what's the most important thing, is whether you were in status at the time you filed your asylum application. If you were not in status at the time you filed your asylum application, you will most likely not be able to adjust status based on the application that your father has filed, which has now become current. So you have a couple options, again, under normal circumstances. You might be able to go overseas and get a green card through the embassy. But if you had a long period of unauthorized stay, that won't work. So the big question here, and it is an interesting question and an interesting case, the big question here, and there's an argument. It's not necessarily a 100% winning argument, but there is an argument that when you were in the United States with this pending asylum case, that you were in a form of status that would allow you to get a green card. There are cases that go both ways, and this is why I said you should probably talk to a lawyer, because it's not a slam dunk. It might work, and it's definitely worth talking to a lawyer, because you might go from somebody who's just seeking asylum to a lawful permanent resident, depending on the lawyer's ability to nail down the facts and establish to the satisfaction of an immigration officer that you were eligible to adjust because you were in status at the time that you applied for asylum, and that you haven't done anything to violate the terms of your status since. That being said, real quick, if you get sent to immigration court, then that status that would allow you to adjust through dad is over. So you need to move quickly.
Okay. I already did that one. Okay. Ahmed says, how long does it take to get the work authorization and social security number going down a marriage route?
Yeah, so that sort of goes to that same question. So these days, when you apply for, let's say that you're married and you apply for a green card based on that marriage, let's say you file the application on May 1st, you're going to get receipt notices back around May 20th. You're going to get a fingerprint notice in the mail around June 1st. You're going to get fingerprinted around June 20th or July 1st. And then from July 1st, you're going to wait 4 or 5 months. So it's going to be about 6 or 7 months from after you file.
Okay. This is an interesting one. Mandeep says that they are a nurse from Canada, full-time working in a hospital. How can he apply to work in the USA and get a visa to work in the hospital?
That is a good question. Nurse visas are very, very complicated. I honestly have not a lot of experience with nurse visas. There are some nurses, depending on which level of nurse you are, that are eligible for an H-1B, but most are not. So I would say that if you want to email us, I can put you in contact with my friend. Her name is Tiffany Baldwin, Baldwin. If you email her, the name of her company is Compass Immigration, COMPASS. If you email her, she should be able to answer that question. We don't do nurses visas because they're so much of a specialty.
Okay. Okay, Mahmoud says that he's from Morocco and he got married in September of 2017. They applied in October of 2017, but they just refused their case in the embassy. His wife is older by 13 years, and they want to know what to do now that they were refused.
Yeah, so the $1 million question is, what type of refusal was it? Not all refusals are created equally. If it's a 221G refusal, and then placed into admin processing, what that means is that they don't feel that there's enough evidence that the marriage is valid or that the relationship is real or that the person is eligible to come to the United States. So a we have filed plenty of lawsuits for people who've been refused before. It depends, again, on the basis of the refusal. Sometimes you don't get a lot of information, but they do give you a piece of paper that shows what kind of a refusal that you received. So if it's 221G, that can be overcome. But if it's something else like crime or terrorism or some other form of drugs, some other form of inadmissibility, then that's not something that you could sue over and challenge.
Okay. Barat asks, how many extensions can an embassy ask for in a lawsuit?
Good question. Usually it's about 2 or 3. I mean, right now it's sort of strange times, but typically what happens is you sue them. Depending on which U.S. attorney you get assigned to the case, some might get the embassy working on it quickly, some might get them working on it late. So I would say usually it's about 2 30-day extensions in most cases.
Okay. Mashoud asks, with the new countries listed in the travel ban, will that affect his K-1 visa as well? He says it's technically non-immigrant visa.
I'm sorry, I was spaced out. Can you say that one to me again?
You're good. So Mashoud is from a country that was just added to the new travel ban.
Mm-hmm.
And he wants to know if it will affect his K-1 visa.
It might not. It might, but it might not. So K-1 is, as they said, is not a immigrant visa. So that might be a way to get around the travel ban by having a non-immigrant fiance visa. It depends on the country, and it depends. I haven't actually looked at this, but we have seen it work in other non-immigrant visa contexts. So I think it would work on a fiance case.
Okay.
I see a question there from Rahila, and I know Rahila, so I'm going to answer Rahila's question.
Go ahead.
So Rahila's question is, I filed a lawsuit for my spouse to come here, and the government filed a motion to dismiss. So in a very, very small set of cases, the U.S. attorney files a motion to dismiss, and we are forced to respond to that. It has happened on some of our Iranian cases. It's happened on some other cases. We have won several of these motions lately, and the government is given no more extensions. But other judges sit on these for months and months. And Rahila's question is, how long can the judge sit? Federal judges are appointed for life, and they can sit on a case as long as they want. So we would not be doing anybody any good by asking the judge to hurry up, which is why we can't. So when a motion to dismiss is filed on one of our lawsuits, we've already sort of lost, in a sense, in that, the lawsuit is all about trying to get something finally resolved. And when a motion to dismiss is filed, and the government knows this, that if they have the right judges, those judges might sit on a case for 8 or 9 months. So sadly for Rahila, that's sort of the answer to that question is the judges are appointed for life. They don't answer to anybody, and they can take as long as they want.
Okay. Konja asks if we can take on a case that is already at the NVC.
Sure. Yeah, I actually recommend it. We take over a lot of cases at the National Visa Center. Adela and Andrew have been working on National Visa Center cases for 12 or 13 years. And I think that we could really help people speed that part along, because the National Visa Center is really a place where people get nitpicky and get sort of hung up because of one stupid little thing. And we have a lot of experience sort of working that stuff out.
Okay. I saw one, now I can't find it, but it was about how long an EOIR 29 takes. I'm trying to find the actual question, but I did just see it.
So you still have questions that are going to disappear, huh?
Yeah, they're getting pushed, and then now I lost them.
Okay, well, I can try to answer that one. So generally, I think what the person is referring to is an appeal to the Board of Immigration Appeals. And this is the same answer to the question that was asked by Rahila. So the Board of Immigration Appeals is allegedly the appellate branch of the EOIR. In other words, that if you lose your case at deportation, then you go to the Board of Immigration Appeals. And we would all love to think that the Board of Immigration Appeals is this impartial tribunal or court that gives people appealing those cases a fair shot. But the fact of the matter is that it's nothing more than an arm of the Attorney General, and that they do everything that they can to deny appeals. So I would imagine that most appeals these days are taking anywhere from 8 to 12 months. Unless the person's detained, those tend to go a little bit faster, but they can take as long as they want, and they can do whatever they want. So if you're relying on relief in the Board of Immigration Appeals, you're probably in a bit of trouble.
Okay. Israel says that he did not apply for a parole when he left the U.S. while his asylum case was processing because he had an emergency. So he's been out of the U.S. going on 2 years now. How can he get back in to finish his asylum case?
I think his asylum case is over. I don't think he's going to be allowed back into the United States, and I think that he shouldn't have left without doing that. So I think that it's very unlikely they're going to allow him back in the United States. I believe that his asylum case was probably deemed abandoned, and he's not going to be able to come back in.
Okay. So Randy says that his wife filed an I-130 for him, and it has a priority date of February 21st, 2020. Will the new law affect his case? My guess is that means public charge. Will public charge affect his case?
Public charge went into effect in March, I think, right? Yeah. So I think as long as it was filed and receipted before, let me see. Let me just check real quick. The days are all running together.
Mm-hmm.
We should do a video on this. When did public charge start? What day did he say he filed?
He had a priority date of February 21st, 2020.
Yeah. Yeah, the public charge began February 24th, so we got it in right under the wire. That was a good thing to do. What this means is he's not going to have to go through all that rigmarole, hopefully, of dealing with the new public charge rule, which is a lot harder and much more difficult for people to get green cards based on marriage or family relations into the United States.
Okay.
Well, I see one in there we should do. Conjo wants to know, will the COVID-19 stimulus checks affect my case at all? Haha. Now, we've definitely done a lot of videos on the coronavirus, and here's where I'm coming down. If you are a citizen, obviously it's not going to affect you. If you have your 10-year green card, this is not going to affect you. If you have your 2-year green card, this is not going to affect you. But if you are in the United States and plan to apply for a green card, you should not cash that check, and you should not spend the money if it's deposited directly into your bank account. My interpretation of the public charge rule would include payroll relief or wage satisfaction elements of that. So if you plan to apply for a green card based on employment or based on family, i.e. marriage, then I would say it is going to affect your case, and you should not take it or spend it. If you're going to apply for a green card based on asylum, the public charge rule would not apply for you, so you could take it. So that's the general gist of what we're telling people. There's a lot more about it on our YouTube channel. So I hope that answers the question.
Okay. I've also been seeing this question a lot everywhere, if unemployment will make them a public charge.
Well, that's so much fun, because some of you might know that I practice with my wife, Amani, and we've been fighting over this issue for the last 6 months. I always took the position that unemployment benefits are money that you paid into the system by working, and that if you are unemployed, that's not a public benefit. I believe I'm right. I think I'm more right than I ever was. I've seen a lot of people who've been asking this question, and all the answers I've seen are that I'm right, that it does not include unemployment benefits.
Okay. Karan says, is there any way that they can extend the EAD in case they don't land a job in the 3-month EAD period?
So that sounds like they're talking about OPT. What was the person's name?
Karan.
So Karen? Karan. Yeah. When you're in the United States studying on an F1 visa, and you apply for optional practical training, which allows you to stay in the United States for either 1 or 3 years based on your major, and to be able to work based on that. You do that by filing for an EAD based on that OPT. And typically you get that shortly after you graduate, and you have a total of 90 days of unemployment. Those 90 days cannot be extended. It's either yes or no. You're either in status or you're not. If you haven't worked in 90 days, you have to notify your DSO at the university, and your OPT will be terminated and you will be out of status.
Okay.
That's another good video idea. OPT and unemployment.
We're actually getting a lot of questions about OPTs and H-1Bs.
Oh, really? Well, on Thursday, I'm going to do a presentation for a local university for all their international students, but we should probably work that into the mix of doing one. I've never done an international student one, and as it relates to going from an F1 to an H-1B, but we should probably do a public one on that.
Okay.
But also, well, actually, yeah, that thing's not working right now. Go ahead.
Okay. I saw it. I can't find it now. Oh, Lorena says that they're on an F1 visa and they're graduate in May. They already got their EAD card to work under OPT. She has several job offers, but she wants to accept the offer that will increase her chances for an H-1B. Is the cap exempt for the H-1B lottery for the type of employer or the type of job?
The only cap exempt H-1B applications are jobs at what are called institutions of higher learning, basically colleges and universities. So cap exempt runs with the employer, not the occupation. So that the best way to find, I believe, employers who are willing to sponsor for an H-1B is to go to a website. It's called myvisajobs.com, www.myvisajobs.com. If you go to that website, you can put in your occupation or your job type, and you can put in whatever state you want to live in, and you can see who has sponsored people in this occupation in this area. Because I think that the people who are most likely to sponsor are those who have been through it already. So that's going to be your best bet. Go to myvisajobs.com. And I think your analysis and your plan is a very good one. I think selecting your future employer based upon who is most likely to sponsor you for an H-1B is the best use of your OPT time.
Sorry, I think there's a car alarm going off. It's pretty loud if you can hear it.
Yeah.
So Asan says, is there anything that we could do currently? He's waiting for an F1 visa, about 9 months in administrative processing. He's a student from Iran.
Yeah, so in the last 6 months, we have filed probably 4 or 5 lawsuits on behalf of usually 5 to 7 Iranian F1 student visa holders. They sort of get together and we file one lawsuit for all of them. And once we file the lawsuit, things start moving. There's so many things going against Iranian international students right now. The coronavirus hit there big. They weren't being allowed into Armenia or to Turkey to get their visas. So even on the cases that we filed lawsuits, they're all sort of in the wind right now. When things settle back down, the best way to get out of administrative processing as an international student from Iran is to file a lawsuit, whether it's with you or with your friends. Either way, that's the only thing that's going to work.
Carrie says that she was adopted from Korea and she got a non-expired alien resident card. She grew up believing that she was a citizen and recently discovered that that may not be the case. How can she verify her status? And also, if she needs to, should she file for an I-90 before an N-400?
What's this person's first name?
Carrie.
Carrie, you need to talk to an immigration lawyer. This is one of the most complicated areas of the law. I suspect that you may not be a U.S. citizen. I also suspect that if you are not a U.S. citizen, but you voted or marked that you were a U.S. citizen, it's very serious. It's all going to come down to how organized your parents were and how what particular laws were on the books at the time that you came to the United States. It's going to depend on what kind of a visa that you had when you entered, and it's going to depend on whether they readopted you when you got to the United States. So there's lots of different pieces to this that can impact the final decision on your case. So you're going to want to do a Freedom of Information Act for your entire immigration file. You want to get all of your immigration paperwork from your parents, and then you're going to want to talk to us or someone here in our office, because these cases are very interesting from a lawyer standpoint, but they're also very stressful from the people who may be finding out, like you are, sort of for the first time, that you might not be a citizen. And so we've seen cases where parents have come back from overseas and basically thrown the paperwork in the drawer and not done anything that they were supposed to do. We've had situations where we've helped people complete an adoption after the fact. So there's lots of moving parts. It can even depend on the situation in your home country at the time that you were adopted. So this is something we know how to do, but it's pretty tricky, and I don't think you're going to be able to figure it out on your own.
Okay, so Tram says that they are on an F1 visa and they were approved for a green card 2 years ago. Are they allowed to receive any support such as Fafsa for tuition, healthcare, and are they able to work legally in the U.S.?
They have their green card?
Yes, it says they were approved 2 years ago for an immigrant green card.
If they have their green card, then the answer to that question would be yes to everything that they just asked. Green card holders can work in the United States. They can get health insurance. Right now, the law says that won't affect any future application for citizenship.
Okay.
I think we have time for one more, eh?
Yes.
5:25. Yeah.
Yes. My screen just freaked out. Sorry.
Oh, I can find one.
Oh, there we go. Okay. Okay, so Adit says that he is in the U.S., but his I-130 case got denied for an interesting reason. The biggest reason was that his dating profile was still on the website. They doubted the validity of the marriage because of it. What would be the best course of action now? Appeal or refile?
Refile. You always refile. Yep. You're not going to waste your time with an I-130. Number one, it won't give you any real status. Number two, your work authorization will expire. Number three, most appeals are denied. So that's one where you're going to want to refile and file a much stronger and, no offense, smarter application. Having your dating profile still on is not a good idea.
Okay. That looks like the last short one.
Okay.
So.
How about Roberto? Roberto wants to know, would me moving to Mexico to wait for my wife's interview be a problem? Generally, Roberto, no, as long as no one can say that you abandoned your residency. So make sure that you're still paying taxes, you're still keeping your property. You don't want to like pull up stakes and go live in Mexico, because then they're going to say that you sort of abandoned your residency, and you're going to have to reprove or reestablish your residency in the United States, which is sort of a pain in the butt. So short trips are fine. Long trips where you sort of empty out your apartment and move and take every earthly belonging with you, that's a bad call. So, all right, Mackenzie, thanks for making time for me. That was good. I think people got a lot out of it. We had a lot of people on the call. Obviously, we didn't get to every question, but if you guys have questions, you can email us at info@hackinglawpractice.com. You can call us at 314-961-8200. You can join us in our Facebook group, which is called Immigrant Home. And we have a lot of good immigration discussions in there. And then we also have our YouTube channel, which hopefully you are all subscribed to. And we are adding one video at least every day. Thanks, everybody, for saying thank you. Arena, we'll see you later. Everybody, thanks so much. Peace out. We'll do this again in 2 weeks, all right? All right, stay safe.